Please be seated. Thank you, Mr. Blackburn.
Thank you.
We'll reassess round.
Now, Mr. Blackburn, where we were just before the lunch break was I had asked you about paragraph 118 of your witness statement, where you had identified the December 22 date as the target date for achieving advanced maturity on the financial crime and compliance program. And you said that you remain of the view that you can achieve that target subject to these resourcing issues that you identified. Now,
yes, that is my aspiration. And that would be in aggregate that we can reach that stage. So there will be some elements that may not yet be advanced, but there may be other elements that are well advanced.
Well, separately from your aspiration, can I ask you whether you expect, subject to the resourcing issues that you've identified, to meet that target date?
Assuming there are no material changes, such as an AUSTRAC enforcement investigation result, then yes, I am confident that we can meet those dates.
Now, the Transformation Program Steering Committee status updated the 6th of October, to which I took you before lunch. That's CRW 700 100 1664.
Yes.
I'm just going to show that to you on the screen now, Mr. Blackburn, at page 1689.
Yes.
This is the commencement of the status report for that committee in respect of the financial crime and compliance change program component. And the
yes.
overall status there is, do you see at the top, or second from the top, is amber in the executive summary?
Yes.
And it identifies that a point that you made, I think, before lunch in your evidence about resourcing pressures continuing in relation to the change program. And we note here that when we go down the page, resourcing is shaded red.
Yes.
And is it entirely due to the requirement to respond to regulatory and other inquiries that is driving the resourcing issues, or are there other factors that are causing the resourcing constraint?
I would say the material impact on the resourcing constraint relates to, two royal commissions, as well as an independent monitorship in New South Wales, together with 2 AUSTRAC enforcement investigations, 1 ASIC investigation. Collectively, these put considerable pressure on the existing team, but that's precisely why I was growing the team in the first instance and why I sought PwC support. So this is the color red there would be an accurate representation of my view at that point in time, yes.
But the question was, are there additional matters operating to constrain resources at this point?
Sorry, did you hear the first part of my answer? Related to 2 royal commissions, 1 independent monitorship, 2 AUSTRAC enforcement investigations, 1 ASIC investigation. Collectively, these place strains on existing resources. So collectively, how we've approached that is to, first of all, increase our existing FTE, and then beyond that, to supplement with externals.
So separately...
Does that answer your question? Separately
from those matters, are there circumstances operating to constrain resources at this point?
No, not to my knowledge.
There's you mentioned here, we're in the middle column of the page, the last dot point. Effectively what you're saying here is you've identified the need for 9 full-time equivalent positions to resource
supplement, yes,
this response. And through a bit of internal juggling, you've been able to reduce that to an additional 4.5 full-time equivalent positions that are required.
Exactly.
But do they remain unfulfilled?
No, we're in the process of filling those, and we've also asked for supplementary resources from our friends at PwC.
All right, but have any of those positions been filled?
As in instantly filled, no. There's a little bit of time that's required in order to bring in the consultants, particularly given the licensing requirements and We also apply for AUSTRAC exemptions in the context of sharing SMR information. So there is a bit of a process to bring those on.
And is there in addition to the resourcing issue that you've identified there, is there separately a shortage of IT resourcing for the financial?
The IT resources, I don't believe there's a shortage, but I believe there are different priorities that the IT group is focused on. So happily, we've met with IT. We've formed a committee that is a FinCrime or FCCP IT committee where we're rallying those priorities to ensure that we have the right priorities. So technology will be, it is a cornerstone to the project, and it's critical that we continue to work with technology. But in my opinion, the technology resources, when we've asked for them, are made available.
And is it the case that in the front line, particularly in Perth, the resources that are there are having difficulty keeping up with the processing of unusual activity reports?
No, not really. I mean, because this is one of the great benefits of having a group approach, is that we don't simply require all UARs that arise in the context of the Perth casino to go to people that are sitting in Perth. They go to our friends in Melbourne and Sydney as well. So we do have a number of UARs that we are working through from the past, and ones that arise out of the results from the external reviews. However, I'm not particularly or acutely concerned with the turnaround time on Perth UARs.
Returning to the page that you have in front of you on the screen, you see down the left-hand side, you've got scope, plan and resourcing.
Yes.
But when we come to plan, is what's being identified there and encompassed within the category plan, the work to be done to actually roll out or implement the change program once it's been designed?
I'm sorry, I misunderstood your question, in part simply because I was looking for the section on that page that you're referring to. So full left column, scope, plan, I see it now. Scope, plan, resourcing. And sorry, your question specifically was?
So in relation to the plan,
Yes, yes.
does that comprise rolling out, or the plan for rolling out the change program once it's been designed?
Well, the change program has by and large been designed. The change program is at a relatively advanced stage now. There are components of it that remain to be designed, but most of it has been designed. Much of it now goes to implementation of the program.
And has the implementation been planned?
Yes.
So what does this amber reflect here against plan?
Wherever, so the plan would be impacted by the resourcing. And so wherever there is a roll-on effect from resourcing, I'm cautious about the colors I use in representing status, because I'm concerned at all points with ensuring that no one is under any false information, that we're, everything is running smoothly and perfectly. So I take a cautious approach and identify it as amber. So in the context of the plan, it is mostly impacted through resourcing and getting those IT dedicated resources focused on the plan, on the implementation of the plan.
But what does plan mean here? What is the concept?
It means the components of the program, of their overall plan. So the components of the program that relate to, so this is the streamlined status. So for example, the plan in the context of the EWRA, which is one of the components of the overall plan, would be the development of the policy, development of the report, based on objective reviews of the controls and of the evidence of inherent risk, et cetera. So it is the sort of meat of it, if you will.
Now, if we go to page 1697, we have what's called a risk assessment charter here.
Yes.
And in the right-hand column, there's key deliverables. Now, Horizon 1 is from July 2021 through to the end of this year. We've discussed a couple of those this morning, the elements of it.
Yes.
Is it correct to understand it this way, that Horizon 1 is the design of the change program, Horizon 2 is broadly its implementation?
I see Horizon 1 as the design and implementation, and then Phase 2 or Horizon 2 as the uplift, so further enhancement to each component of the plan.
So there are no planned due dates against Horizon 2?
No, it's important for us to complete Horizon 1 to understand the results of the EWRA and its constituent elements, including the JRA, CRA, CHRA, and product risk assessment, in order to then determine what uplift is required. So let me give you an example. In the context of a CRA, customer risk assessment, there are certain attributes that we're building out right now, 7 attributes to assess our customers against, together with behavior. As our technology ability or as our information on hand, so the KYC we collect becomes broader, it will give us an increased ability to enhance the CRA to even sort of focus the results.
So let me understand then, when you talk about the target for advanced state maturity by December
Yes.
2022, does that
Yes.
involve any part of Horizon 2 plus?
I imagine it will, yes. There will be components of that will take us to a further advanced state, such as, I'll give you another example in the context of the CRA. As we increase our ability to identify through electronic means and verify information about our customers, that will invariably lead us to the greater purpose, which is an advanced ability to identify risk.
Is it possible to reach the advanced state only by reference to the activities in Horizon 1?
No, not likely.
All right. So you must have, I suggest when you say, well, I'm confident that we'll reach advanced state by December 22, have in mind that one or more of these elements in Horizon 2 will be completed by December 2022.
It likely wouldn't be singular. Rather, what would happen is D3, D4, D5, and D6, if I'm saying that correctly, are all elements that will have further evolution over the course of the 2022 year, and that will allow us to reach a further advanced state. So as you add complexity and you add sophistication to your methodologies and your models, invariably it leads to a more advanced state. But it will be, as I said, with the EWRA, it's a never-ending process. This is evergreen in that we will continue to enhance these over the course of many years. And it may be that we stabilize at an advanced state. It may be that we move to optimize, but it is an ongoing evolution.
Yes, but you're confident that you'll reach an advanced state of maturity by December 2022?
Assuming that there are no intervening material matters, like I suggested, yes.
And that's at least in part dependent upon elements of Horizon 2 being completed by then?
Yes.
Yeah. But none of the activities in Horizon 2 have been planned yet, is that right?
No, that's right, because in order to plan Horizon 2, you need to finalize Horizon 1. It's fairly simple. There's not a lot of complexity to this. So what I'd suggest you do is break it down a little bit. So consider JRA, CHRA, PRA. All of these are fairly simple methodologies that are applied to determine the risk associated with a product or channel. By adding additional factors that go into the methodologies, we will get to an advanced state. So it's as simple as adding additional fields. It isn't something that necessarily would take many years to reach.
Well, you don't know when you'll reach it until you plan it, is that right?
I do know what I expect of an advanced state. And yes, I do know when I'll reach an advanced state based on my expectations of an advanced state. So again, by way of example, CRA, it's simple. We look at 7 factors at this point in time. If we increase that to 9 factors to include a couple of additional factors related to behavior, I would see us in an advanced state.
And will there be a plan produced for Horizon 2?
Of course.
When?
Again, once Horizon 1 is complete,
Which is
so that I'm in a position to then evaluate what's required for Horizon 2.
And when will Horizon 1 be complete?
For all intents and purposes, by the end of 2021.
Although in D2 there's a date of June 2022 there.
Yeah, but that's not necessarily required for the advancement of the next phase. Most of the other components are.
Would you agree that how well the change program is embedded once it is introduced depends to a large degree upon training and culture?
I'm sorry, you phased out a little bit at the end from a volume perspective. Could you just the end of the question?
Would you agree that how well the change program is embedded once it is introduced depends to a large degree upon training and culture?
Yes, I do.
And have you reviewed the cultural survey report prepared by Deloitte's most recently that breaks down survey results for individual properties, including relevantly Perth Casino?
Yes, I have.
Would you regard those results as indicating that there may be impediments to embedding the change program at Perth Casino and therefore its ultimate effectiveness?
No, I've considered the cultural situation. Nothing in that report was a surprise to me after joining Crown and having been here for 9 months. So there were no true surprises there, and I anticipated that sort of environment in developing my plan.
So
that is typically what I do. When I was hired at NAB, it was the same. When I was hired at CAVC, it was the same. It's to come into a situation where there may be cultural issues, there may be other issues with respect to financial crime obstacles, and that's how I plan.
now the assurance and testing of the new program, the change program, does it work this way, Mr. Blackburn, that you are confident that you'll reach an advanced state of maturity with that program by December 2022, but then after that, the assurance function has to basically swing in to verify that?
No, it's not iterative. It happens concurrently.
So when do you expect the assurance function to be able to verify the effectiveness and maturity state of the program?
Pursuant to their path, it's not a singular objective. That is there are multiple components to that, and that's what I was speaking of earlier when we were talking about the rollout of the assurance plan. The assurance plan has several components where elements of the program will be tested by the assurance team over the course of the year. And once each of those elements is tested, we will then be able to feed that back into the program for ongoing development.
I move to an entirely different topic now and talk to you about gambling-related harm minimisation, Mr. Blackburn. You're open in your business statement that you do not have any previous experience in this area.
That is correct.
And you don't have any relevant qualifications such as a psychology degree.
I do not.
You don't consider that it is necessary for you to have such qualifications or experience to lead the responsible gaming or RG function, as Crown calls it?
I do not. I feel I bring different attributes, but I also bring a certain level of seniority. Like any senior executive, I will staff my team with competent experts in the field. And so that allows me the ability to, frankly, advocate on behalf of the function, just as I advocate on behalf of other integrity functions like financial crime or compliance.
So do you consider that that same reasoning applies to the financial crime and compliance function in this sense, Mr. Blackburn, that although you are in fact deeply experienced in that area, it is not in fact necessary for you to have any experience in financial crime and compliance to lead that function?
I wouldn't say that, but I would say this. If I were an RG expert, and I'm not, but if I were an RG expert and I was put in a position that I'm currently in, I think I would have transferable skills to apply in the context of fin crime or compliance, notwithstanding that I was not an expert in that field. But I do think it's important to be a proven expert in an integrity function in order to run an integrity function and a risk management function, essentially.
But to be clear, if you had deep experience in gambling-related harm minimisation, your position is that you would be well equipped because of that to lead the
Yes.
financial crime and compliance function, even though you had no experience in that area.
Well, based on my 9 months of experience, and I appreciate that's not a great deal of experience in this space, but based on my 9 months of experience, I think there are many transferable skills that cross over. But again, I go back to the point that in any role at this level in the organization, as a group executive reporting to the CEO and also reporting to the board, my expectation is that I will bring in experts in every field. And notwithstanding I may be a financial crime and compliance and risk management expert, I have introduced other really terrific experts in financial crime. I'm about to in compliance. I've done so in operations as well. And as of today, I issued an offer to a global expert in responsible gaming, not based in Australia, but that I would see introducing to our program. And assuming she accepts the offer, or if we get to the position where the offer is accepted, this will be the most senior responsible gaming role at any major casino operator globally. So if you'll appreciate this, an EGM level responsible gaming, fully dedicated responsible gaming employee is the most senior at any of the casino organizations globally. At the EGM or typical EVP level, depending on your jurisdiction, almost all instances of responsible gaming are tucked into other roles, including social responsibility and other functions. This is a unique global precedent that we're about to set.
Just coming back to you, Mr. Blackburn, is your evidence that
Yes.
your role in relation to financial crime and compliance does not need to be filled by someone who is an expert in financial crime and compliance?
I think my role needs to be filled by an expert in risk management. I would suggest that is the core function of what I do, and that crosses both the compliance function and the financial crime function. However, I think it's very helpful that I have a financial crime risk management and compliance background, both for those components and for the responsible gaming area.
And do you accept that similarly it would be helpful if you had a subject matter expertise in responsible gaming?
I accept that, and that's why I'm quite encouraged and frankly excited about the prospect of deepening my knowledge in the space.
Coming back to responsible gaming, and I want to ask you some questions about the approach to your role. Would you agree that there is significant division or differences of opinion within the academic literature and research in respect of the causes of gambling-related harm?
Yes, I would, from the research I've read.
And also significant divisions about which models or approaches to gambling-related harm minimisation are most appropriate or effective?
Certainly.
Would you say that in the time you've occupied your role at Crown, you have developed a clear view of your own about the causes of gambling-related harm at Crown casinos?
No, I wouldn't say I have a clear view. I have a clearer view than when I started in the role, but I think more time is necessary, more exposure, more experience is necessary to fully understand that. I also think that that's where I happily rely on my experts, happily introduce new experts into the team, but also on the Responsible Gaming Advisory Panel, I rely on the input from our experts as well to ensure that I'm across. I think you'll probably also appreciate that at every senior level, let me give you by way of example, a CRO in a chief risk officer in the context of a bank will never have experience in every one of the risks that they are responsible for, but they run the function because they have transferable skills.
Just in terms of the views you've been able to develop so far since you arrived
Yes.
at Crown about the causes of gambling-related harm at Crown's casinos, can you concisely articulate what those views are?
My views on, sorry, which component?
The causes of gambling-related harm at Crown casinos.
My impression at this stage, my perspective on it is that the causes are consistent with gambling-related harm at all casinos, all land-based casinos, which relate to the individual and a number of factors behind that individual, but it could be their genetics, it could be their context, it could be their environment, it could be their social circles. There are a number of factors that could go into whether or not they experience harm.
Do you perceive any of the products that Crown offers as being causally related to gambling harm?
I'm not sure I would say causally, but I do believe that certain products at Crown and other casinos and frankly pubs and clubs in many jurisdictions, not Western Australia, but other jurisdictions, there are products, namely EGMs, that are consistently cited in the research as being problematic, depending on the settings of those devices.
Have you developed in your time at Crown a clear view of your own about the model of harm minimisation that you consider to be most effective or appropriate for Crown casinos?
It is my personal philosophy that the model needs to embrace, frankly, all elements. So it needs to focus on harm prevention, harm minimization, and addressing the problem gaming, so the actual resolve or resolution of problem gaming. But I think it's a collection of all of the above. So informed choice, harm minimization, harm prevention, consumer protection as well.
And is that, to your knowledge, a view shared by the Responsible Gaming Committee of the CRL board?
The Responsible Gaming Committee of the CRO board is informed by the advice provided to it by myself and by the RGAP and by the general managers in the responsible gaming space, but I think you'd need to ask them for their opinion.
Do you intend to advocate that your views about the appropriate model be accepted by the Responsible Gaming Committee?
That is my intention out of the Responsible Gaming Change Program, to come forward with recommendations for the Responsible Gaming Committee to consider in the implementation.
Do you consider that Crown has a responsibility to modify or restrict when or how it offers gambling services in order to minimise the risk of harm related to gambling-related harm to patrons?
Specifically, your question is when it operates? Is that, sorry, could you just repeat the question again? I just want to make sure I get it all.
Do you consider that Crown has a responsibility to modify or restrict when or how it offers gambling services in order to minimise the risk of gambling-related harm to patrons?
I believe how is absolutely a responsibility of Crown. But when, I think, is a bigger question, one that I'd need to consider research on. But how is certainly within the power of Crown to manage. I do think that, although I also feel that there is a responsibility for governments, responsibility for regulators, responsibility for the industry, such as Crown, but also for the communities and the individuals themselves. I think it's a shared responsibility model.
And you hesitated at the when. Can you just explain that, please?
I think you can manage responsible gaming, or you can manage the risk of harm differently at different times. So you can meet the requirements at different times. So I don't think when is a factor. I think it's how you address it at particular times.
Do you consider that Crown has a responsibility to modify or restrict how it offers electronic gaming machines to the public in order to minimise the risk of harm?
I do.
And might, in that case, electronic gaming machines specifically, might there be a justification for also modifying when those machines are offered to the public?
Not necessarily, because by way of example, if there is heightened use of EGMs or a larger number of customers, so let's say a Saturday night between 1 and 2 a.m., if there is an increase in usage, then my response to that would be increase our monitoring, increase our oversight in order to ensure we are doing our best to prevent harm. So it's not that it's a problem that the EGM is running at 1 to 2. It would be a problem if we weren't adequately staffed to address it or using technology to address it.
So you don't perceive EGMs as being in any way analogous to something like alcohol, for example, where there are legal restrictions around when alcohol may be sold or served?
I don't, but that's a personal perspective, and I'd suggest that to come to a sort of Crown view, I think I probably have to research it further.
Now, if we go to page 1013 of your witness statement at paragraphs 31 and 32, you're referring there to regulatory compliance. Just get that up, please. Compliance with laws and regulations. And then in paragraph 32, you're referring separately to a moral obligation to work towards minimising potential harm from gambling at the Perth Casino. That's a condition of Crown Perth's social licence. Just want to ask you some questions about that paragraph 32.
Of course.
You say Crown recognises it has a moral obligation to work towards minimising potential harm. Do you understand this to be a best endeavours obligation?
I understand this to be a social expectation and a community expectation, and therefore a requirement for us.
Yes, I'm asking for the content of the obligation, Mr. Blackburn, and I'll put it this way. You're using this language of obligation to work towards. Are you trying to express a best endeavours obligation, or are you saying independently of any legal or regulatory requirements, Crown has a responsibility to take all reasonable steps to minimise potential gambling-related harm?
I would say the latter.
And when you say minimising potential harm, I understand from an answer you gave a little while ago that you include with that preventing harm from occurring.
If we can, yes. So there are opportunities, I think, in that space that we can further explore, and enhancements we can make to our program to work on prevention. I think we do have elements of it. This is one of the components of Professor Rockcliffe's report that I didn't quite agree with or didn't quite understand, is our approach at this point in time is not solely informed choice. It's informed choice, it's harm minimization, and it's harm prevention. We take steps to attempt to prevent through awareness, through internal training of our own employees, but also through awareness with the public. I think we could do more, which is part of the reason I've considered this as a component of the Responsible Gaming Change Program.
So coming back to the moral obligation that you've identified in paragraph 32, that obligation to work towards minimising the potential harm from gambling, how do you define harm?
Harm, simply put, I think harm means spending more money than one has, or spending too much time or more time than one has. So it's a time and money consideration.
Now, you make the point at paragraph 35 of your witness statement on this page that legislators and regulators have an important role in setting and enforcing policy. Just open up 35, please. Thank you.
Yes.
And you say it's critical for organisations such as Crown to have that policy direction. You would nevertheless accept, though, wouldn't you, that absent such policy direction and separate to it, it's necessary as a condition of Crown's social licence for Crown to formulate a coherent approach to harm minimisation and to effectively implement that approach.
I agree with that.
And that would be, you would agree, as an aspect of its responsibility, the moral responsibility you've identified, to take all reasonable steps to minimise potential gambling-related harm.
Yes, I agree with that.
Now, paragraph 19 of your witness statement, this is pages 110 to 111, you describe in the last sentence of that paragraph your substantial experience in implementing reform programs. You use this language for functions that operate as integrity-focused cost centres. Do you see the responsible gaming function at Crown Group as an integrity-focused cost centre?
I do.
And you mean by that money has to be spent on that function for integrity reasons?
I believe for the social license of an organization, you need to focus on integrity. And in order to do that, you need to spend money. So that's where the cost center component comes in. But it is focused on functions that may be perceived by others to be obstacles to profit.
The cost centre, such as this integrity-focused cost centre, does not typically directly generate any revenue or therefore profits for the business. Is that usually how it goes?
That's correct. So that is typically your compliance function, your risk management function, your financial crime function, and also your responsible gaming function, in my view.
Do you see your role in heading the Crown responsible gaming function as requiring you to consider and balance the costs of the harm minimisation system against the effectiveness of that system?
I think that is that's a requirement in all functions in a risk management capacity, including responsible gaming. There needs to be a balance, but you need to. Different people may perceive the parameters of that balance differently. My view is that, and I've articulated this in the context of financial crime projects and risk management projects in the past, is that you need to be able to not simply meet regulatory expectations or regulatory requirements, but to exceed them and to ensure that you are doing the right thing by vulnerable people.
Now, on a related topic to the costs of integrity-focused cost centres, do you consider
Yes.
the question of whether a harm minimisation measure, if implemented, would put Crown at a competitive disadvantage to other casino operators, informs whether or not Crown should take that step?
I think it's relevant to Crown, but I don't think, well, I think it's relevant to Crown in the context of we also are a business. We have shareholders that we are responsible to. And the government has an interest in ensuring that the competitive playing field is fair. So my perspective is that changes that are made to one organization in the same space should apply to all organizations in the space so that there is consistency. There is a potential competitive impact, as we've seen in some of the research. Professor Blazinski has produced papers on this as well, where arbitrarily applying draconian measures causes organizations to not survive. In fact, I think in the UK, it was something like 10% of organizations in the casino sector were ultimately closed because of very strict draconian measures that could not be equally borne by each of the organizations that were subject to them. So it strikes me that we have to be commercially reasonable, but at the same time, we need to do right by the vulnerable.
Beside draconian measures and just look at reasonable ones,
Yes.
Would your approach be that if a step is reasonable to take to prevent harm minimisation, it matters not whether it puts Crown at a competitive disadvantage to other casino operators?
Well, to the extent that it impairs Crown's ability to continue to operate, I think it would, but in most cases that won't be the case. So I don't think that it is. It's necessarily it's not necessarily the conclusion that by virtue of taking steps to reduce harm will necessarily lead to competitive challenges as well. I also think if responsible gaming is done right, and granted, I'm not an expert, but based on my experience to date, and also based on the research that I've done, I don't think responsible gaming is inconsistent with profit. I think it can be done in a way, so long as it's done uniformly across an industry, I think it can be done in a way that sort of encourages responsible growth.
Now, if I take you to paragraphs 20 and 21 of your witness statement, this is on the same page 1011, you explain there about the expertise that you can draw upon in your responsible gaming role. And you mentioned the RG team that reports to you, which you say has deep experience.
Yes.
Exposure. But of course, they're accountable to you, aren't they? Your lack of subject matter specific expertise doesn't permit you to be able to assess whether what they're giving you by way of advice is the best advice or something that should be accepted or not. You'd agree with that?
I wouldn't. I find it mildly insulting. I think I'm a relatively intelligent person, and I'm able to apply critical analysis to what I'm hearing, and also to challenge questions where information is presented to me. I'm also easily able to call upon the RGAP, the advice from the RGAP, to counter that advice, as I've done in the past, to seek additional advice to ensure that I'm acting in the best interests of the customer in this case.
Now, you mentioned at 20 the new Group Executive General Manager for Responsible Gaming. That's a new position as someone whose expertise you can draw on. And I assume that this is the role that you were speaking about previously that you have identified that you view with some excitement.
I do. As I mentioned, I presented an offer earlier today. It was actually yesterday. It was well received, and I'm optimistic that we may be able to fill the role in the near term. And this person would bring global expertise, is a renowned both academic and practitioner in this space, has clinical experience as well, and would bring a wealth of experience.
And do they have a behavioural science or psychology background?
A doctorate, yes.
Now, can I just come back to the job description for this role that you referred to at paragraph 84 of your witness statement? This is CRW 700-1043-138.
Yes.
And on this page, in the second dot point, the second dot point, please. Refers to what this role is responsible for. Relevantly, in the second dot point, design, development and implementation of a comprehensive RG program. That's
yes.
The objective of Crown. Is it to develop a comprehensive RG program?
Yes, it is.
What is meant by comprehensive there?
To cover harm minimization, harm prevention, and problem gaming management.
Now, given that this is the responsibility of this role, which is a new role, and a person hasn't
yes.
been recruited into it yet, has the design, development and implementation of a comprehensive RG program commenced yet?
It has, so elements of it have commenced. As you'll be aware, Crown is made great strides towards addressing the recommendations from the Victoria Royal Commission in their 6th casino review. Subsequently to that, we had 17 recommendations provided by the RGAP, which we are also well along the implementation process. There's only a few that remain outstanding. Of course, there are the RG enhancements that I proposed to the board in May, which are also well progressed. All of these things in aggregate, taken together with the results of the Victoria Royal Commission and the recommendations of the Commissioner Finkelstein, have been built into the RG change program that we will soon be finalizing in terms of the program. And then that will launch, though I fully anticipate, based on my experience through the interview process, that the individual that I introduce will have a view and will want to take a perspective on what that RG change program looks like going forward. But notwithstanding that, we're progressing at pace.
So the RG change program that you say is about to launch, is that a comprehensive RG program?
In my opinion, it is, and though I will readily ask my new EGM whether or not she believes that's the case, assuming that the offer is accepted. And I will say that it is informed by the RGAP. So happily, we've had input from Drs. Nauer and Del Fabro and Blazinski on the components of that RG change program, several elements of the components of that change program. So I feel it's as informed as it could be at this stage, and I'm encouraged to have the new individual consider it as well.
Now, if we go to the bottom of page 3140 of this job description, where the qualifications and experience are noted.
Yes.
Just wanted to ask why a degree or a bachelor degree in business management law or an MBA is regarded as relevant to this responsible gaming role.
It's a good question. I think that was a hangover from another job description, so I apologize that that is not what we were looking for, and frankly, that's not what we got. In all of the applicants I've met with, there was an expectation, and happily that expectation was met, that they all had specific RG experience and clinical experience. So that was a mistake in the position description.
So what are the qualifications that are necessary to fill this role?
Significant responsible gaming experience, ideally a degree in clinical psych.
Yeah.
Sorry.
Just be clear, it's qualifications, not experience, that I'm interested in this question.
Okay, understood. Clinical experience, ideally, clinical psychology experience at a minimum, but also an academic background in responsible gaming or that touches on responsible gaming.
So what qualifications are minimum requirements for, not experience, qualifications, academic qualifications that are minimum requirements for this role?
The ones I've just described.
Can you just repeat them, please?
A undergraduate degree, or at least a base level degree in psychology or clinical psychology, and ideally academic experience in the RG space.
Thank you. Now, under the experience heading, and this goes over to page 3141, but it's all been popped out, I think, for you. In that first dot point, the indirection should read indirect, I think, or indirectly, is that right?
Sorry, could you draw my attention to the specific bullet? Which one are we looking at?
First dot point in the box for experience. 10
years experience directly, or yes, that should be, yeah, a few errors in this one.
Yeah, now it says in responsible gaming or a related field. What do you envisage to be a related field?
Psychology.
What do you envisage to be indirect experience?
Well, I would say responsible gaming indirect experience could mean working for a foundation, working for a public entity, not necessarily working for direct experience, to my mind, would be in the industry. Indirect experience would be in any ancillary area to the industry. So government, regulator, community, community parties, and foundations such as the VRGF.
Now, if we go back to paragraph 21 of your witness statement, this is where you refer to the independent advisory panel. Page 1011 of the witness statement. And you understand that that panel is independent of Crown?
I consider them independent in that they are not employees of Crown, though I recognize they are paid by Crown, but they are not employees of Crown.
And you consider it important to take advice that is independent of Crown in relation to gambling-related harm issues?
I consider it's important to take advice from independent experts in respect of every area of risk, including responsible gaming, including financial crime, compliance. I think that objective external advice is necessary to ensure that your program meets and exceeds regulatory standards.
Are you satisfied with the operation and effectiveness of the independent panel?
I think the independent panel is, I'm incredibly impressed with the independent panel. I think they are three very eminent responsible gaming experts. I think there is an opportunity to expand the RGAP to include other input, recognizing, as you said at the beginning of this section, there are many views. And there doesn't seem to be a singular view. There seems to be no agreement in academic research on elements of responsible gaming. And so I'm happy to introduce additional views to see if they differ. However, I'm very pleased with the RGAP as it stands, because I've yet to encounter an instance where they are at all influenced by Crown.
So you're satisfied that it is sufficiently independent of Crown in its operation, that panel?
I have no reason to believe it isn't. They've never challenged, they've only ever introduced concepts and recommendations that appear to have integrity.
How long have the members of the panel held that role?
I believe it was 2019 when the panel was created, though, of course, this was before my time. I joined on March 1st, as you recall, or, well, 24th of February.
Have you formed any views about whether there should be a limited tenure as a member of that panel?
I think that's a useful concept in any panel, particularly external panels. I think it's also a useful concept in the context of boards. So Steve McCann and I will be meeting with Dr. Blazinski, Alex, I believe in the next couple of weeks, to specifically talk about this, about the Constitution and who comprises the panel, and also about how we approach it going forward.
Have you reviewed the terms of retainer of each of the members of the panel?
I have.
And you don't consider that those terms affect or compromise the independence of the panel?
No, I rely on their professional integrity, and I believe I have no reason to question that.
You don't think that having particular individuals on a long-term retainer from whom advice is sought exclusively has a potential to compromise the independence of the advice you're receiving?
I think it could, and that's why I suggested to you that I am a proponent of the concept of terms for independent committees. However, I recognize that this field is fairly narrow, and I'm well versed in that, having run a recruitment process, global recruitment process. it is a sufficiently narrow field that the individuals with eminent experience in this space are not plentiful.
Now, if we go to paragraph 38 of your witness statement, page 1013, you refer to the report of the independent panel dated August 2020. Just on the room screens, please, CRW.507.001.1078. Did you review this document when you commenced in your position heading RG?
Not long after.
All right. And did you form a view about its sufficiency?
No.
Now, at paragraph 39 of your witness statement, page 1014, you refer to the development of what you call, as a capitalised expression or defined expression, the RG enhancements.
Yes.
Which were a set of steps you took in and from May 2021 to improve Crown's responsible gaming system. Is that right?
That's correct.
And you emphasise, of course, that these were just initial steps pending a full transformation program.
Correct.
And that's the program you describe, again, as a defined term, the RG change program.
Correct, yes.
Now, these initial steps, the RG enhancements, you proposed those to the Crown Board, didn't you?
I did, yes.
And when you were giving evidence to the Victorian Royal Commission, you described these RG enhancements as something that was simply common sense to you. Do you recall?
Yes, I did.
Yeah. And by common sense, you mean that you didn't need to take any advice from a subject matter expert about the likely effectiveness of these measures?
Not with these measures.
Or to obtain any...
However, I did consult with an expert.
But you didn't need
just to be clear.
Yeah, but you didn't need to because they were common sense to you.
I felt they were common sense from my view, but notwithstanding my perception, and I engaged with a number of experts. I engaged with my team. I also engaged with the business. I engaged with Professor Blazinski on a handful of occasions as well, just to ensure that that I wasn't acting solely on my common sense.
Your common sense also was this, wasn't it, that they were obvious changes to be made to the existing program that needed to be made?
That's how I felt, yes.
And if we can just identify what those enhancements were, we go to CRW.512.103.0440_R. This is a set of agenda papers for a CRL meeting on the 24th of May, Mr. Blackburn. And you set out a memo to do with responsible gaming that begins at 492, and there's an appendix to that memo that commences at 496.
Yes.
Go there, please. Go to 496. This goes over to the next page, but...
yes.
You'll see there that the time limits on play, you thought a reduction in time limits on play from 18 hours to 12 hours in a 24-hour period was common sense. Is that right?
I did feel that,
Yeah.
and I do feel that.
And your understanding was that the 18 hours or 12 hours, whichever you're referring to, related to a patron being on site at the casino premises with short breaks from play?
Yes, concisely, yes, precisely.
And it doesn't connote them necessarily playing continuously for 12 hours or 18 hours, as the case may be.
No, that's not how our alerting system works. Of course, the alerting system works both in the context of time on machine or time in play and time on site.
And just to be clear, you didn't have any evidence or research basis to reduce it from 18 to 12? It was just something that's obvious to you?
It's something that struck me as common sense, in that I could not imagine someone spending 18 hours in a casino setting. That is a judgment call by me, and one that perhaps should have been better researched. That the challenge is, at least subsequently to that, in reviewing this, there is a dearth of research on this topic.
Well, you understood that 12-hour proposal, reducing it from 18 hours to 12, was something that the CEOs at Perth, Melbourne and Sydney had recommended?
They agreed to it. It wasn't recommended by them, it was agreed to by them.
Did it occur to you at the time that 12 hours was still, from a common sense and obvious perspective, too long and should be reduced further?
It did not, but I committed to ongoing consideration. So I have not yet determined what is appropriate in this context, but I think 12 is more appropriate than 18, which is why I proposed it.
And I think that document that your council produced today and asked you to identify is the policy that introduces that 12-hour maximum.
Yes, correct.
Can I just ask?
It's important to know. Yeah, sorry, go ahead.
No, you finish your answer.
I was just about to say that it's important to say in the context of the 12 hours, it's not simply 12 hours. Of course, there's the 3.5 hour, there's the 6, the 8, 10, and 12 for interactions.
Now, can I just ask you quickly about the bus/red carpet program here?
Yes.
Why was it common sense to you to cease this program with community groups organising transport to Crown Perth?
It struck me as potentially introducing people that could be at greater risk, and in incenting them to attend and game.
Now, over the page where these enhancements continue, you see the first box is cashless. And
yes.
There's a discussion about Crown Melbourne moving to cashless gaming.
Yes.
Why does it not also refer to Crown Perth?
At that point in time, it was only raised in the context of Crown Melbourne. I had not heard it referenced in the context of Crown Perth.
But this was common sense to you, a very obvious change that ought to be made to the RG program, yes?
Yeah, it is, but I wouldn't read from that any sort of exclusion for Crown Perth. That is not the case.
There's a recommendation, you'd be aware of the Victorian Royal Commission in its report, that a direction be given to Crown Melbourne under the Local Casino
Yes.
Control Act there, to the effect that Crown Melbourne phase out the use of cash at the casino,
Yes.
except for transactions of $1,000 or less. Does Crown object to
Correct.
the recommendation?
In principle, no. However, it is something that will take considerable amount of time to implement. But I frankly think, from my perspective, working in financial crime, working in responsible gaming, and in compliance, the concept of cashless above a certain minimum level is one that will greatly assist the reduction in harm, depending on how it's done.
And what's the order of magnitude of the considerable amount of time to implement that you just referred to?
Well, first of all, there's legislation that needs to change in certain states. There is also technology that needs to change. We need to operationalize a new approach, and frankly, it needs to be industry-wide.
Why so?
I don't want to be responsible for driving problem gamblers or financial crime, people that commit financial crime, to entities that are less capable of managing the risk.
Now, what's the position in relation to Crown Perth? Does Crown intend to move to cashless gaming at Crown Perth?
We are considering cashless gaming for all jurisdictions, Sydney, Crown, and Perth, Melbourne and Perth. And and the tool that we would likely use, that we are considering, that is currently under development, that we're in contractual talks in respective, would be deployed at all 3 jurisdictions.
What is that tool?
It is a digital wallet.
Could I interrupt again? Sorry, Mr. Blackburn, you mentioned that you thought that if there is to be this change, it should be industry-wide. Were you speaking?
Correct.
Were you speaking there of the casino industry or the gaming industry generally?
My perspective, Commissioner, is that it should be the gaming industry generally. I think it creates a fair playing field, but it also it protects. I am quite concerned about the introduction of a measure that only applies to certain industry participants that will then drive behavior, and dangerous behavior, to other organizations that are less capable of managing it. And that arises in the context of both financial crime and responsible gaming. And just, it is a concern.
Thank you.
Of course.
Now, the enhancements that you have on these 2 pages that I've shown you, Mr. Blackburn,
Yes.
given that they were to you obvious common sense improvements to be made to Crown's RG system, have you gone back to consider whether or not the independent panel in the 3 years that it has been in place, 3 or so years, has ever recommended those improvements?
So they've recommended a number of these improvements, not all of them, but a number of these improvements in their August 2020 report.
But not all of them?
Not all of them, no.
To the extent that they did not, does it raise serious questions in your mind about the competence, effectiveness or independence of that panel?
Not at all.
If we come back to the August 2020 report, this is just on the room screens, please, CRW 50700111078. At 1083, what the panel's doing here in the dot points, it's identifying strengths in the current framework and initiatives taken. And in the 3rd dot point, it says that Crown has a well-trained and experienced staff cohort. It goes on to talk about its skills and so forth. This is at August 2020.
Yes.
In your evidence to the Victorian Royal Commission, you mentioned you were at a responsible gaming committee meeting in April 2021, and you heard Dr. Blazinski say that, quote, "I feel the group is underfunded and under-resourced." Do you recall that evidence?
Those weren't his words, but yes, that is accurate.
Well, what were his words?
I don't recall, but I would not. Those words would have remained in my mind. So he didn't use those words.
Let's go to com.0004.0031.0367 at page 0494. This is page 3027 of the transcript. Blow up lines 13 to 20. This is your evidence, Mr. Blackburn.
Yeah, that would be my paraphrasing of what Dr. Blazinski said. Those are my words.
So you were stating the effect of what he was saying.
I think I was stating it perhaps bluntly. In effect, what I believe he was saying was that the team was under-resourced, but potentially not underfunded, but remuneration was inappropriate.
I see. Now, you say at paragraph 62 of your witness statement, page 1018, that you were not presented with recommendations made by the general managers for responsible gaming before the RG enhancements were proposed to the board. You did, however, discuss certain proposed enhancements with Ms. Bauer, didn't you?
I did indeed. And Ms. Bauer presented to me the proposed responsible gaming enhancements.
Yeah. And did she inform you where she got them from?
She said she had been working with the GMs, with the other group general managers.
Right. Now, at paragraph 64 of your witness statement, page 1018, you refer to 2 recommendations from the general managers in the first sentence: mandatory carded play and mandatory gaming floor entry registration. You say you did not consider that at the time that either of those matters constituted inadequacies in Crown's existing framework. Do I understand, yes, therefore, that the ones that you did include in the RG enhancements, the common sense obvious ones, reflected existing inadequacies in the framework?
That is my perspective, yes.
Yeah. And if I can take you then to paragraph 57 of your witness statement, page 1018, you are asked to identify in the current framework what was an inadequacy versus something that just needs to be improved.
Yes.
And you answered that it's difficult to distinguish in the absence of legislative and regulatory requirements.
Yes, and I confirm that statement. I think it is quite difficult to distinguish what constitutes an inadequacy versus an opportunity for enhancement. Inadequacies, to my mind, would be instances where we are not meeting regulatory requirements. And as I've mentioned also elsewhere in my statement, there isn't a great deal of prescription around responsible gaming in any legislation in Australia, let alone Western Australia.
But with the RG enhancements, you identified inadequacies in the program, didn't you?
I felt certain elements represented inadequacies, but it is my opinion as to the inadequacy.
Well, you can give your opinion, and that's what I'm asking you for now, Mr.
Yes.
Blackburn. You can determine, and you have determined, haven't you, that to the extent that there were things in the existing program that required the RG enhancements to be introduced, they represented inadequacies in the program?
Not uniformly, no. And I apologize if I left you with that perception. I think in certain circumstances, I regarded elements as inadequacies. In others, I regarded them as opportunities and enhancements, which is why I titled the document Enhancements.
So some of them were reflective of existing inadequacies and some were not reflecting inadequacies, but just areas for improvement.
Yeah, I would say, I mean, if you read it in conjunction with the paper that was covered, that covered this document when it was presented to the board, the paper clearly indicates that I felt that resourcing was inadequate and that remuneration was inadequate. Those are 2 points that I was focused on. The absence of an evaluation, sufficient evaluation, was also something I felt was an inadequacy. The enhancements, the remainder of those documents or those recommendations were essentially opportunities for enhancements, but in some cases I considered them inadequacies.
Now, can I just ask you, really what I want to do is put a proposition to you and ask you whether you agree with it or not, Mr. Blackburn.
Happy to.
You recall earlier I was asking you about the social license or moral obligation in relation to harmonisation. Yes. And you accepted that Crown has a responsibility to take all reasonable steps to minimise potential gambling-related harm.
Yes.
It would be possible, wouldn't it, to identify inadequacies in an RG system within Crown, irrespective of the legislative or regulatory environment, if you could draw a conclusion that Crown hasn't taken all reasonable steps to minimise harm?
It was a very long question. I think I agree, but I'd love for you to repeat it if you wouldn't mind.
So you agreed with me earlier that Crown
Yes.
has a social licence or moral obligation to take all reasonable steps to minimise potential gambling-related harm.
Yes.
Now, before, I took you to, well, paragraph 57, which is on your screen,
Yes.
where you're expressing a difficulty in being able to distinguish between an inadequacy in an existing program Crown has
Yes.
versus a need for improvement or a matter for improvement,
Yes.
unless you've got a regulatory or legislative context.
I don't think so. In response to your question, I don't think you necessarily require a regulatory framework in order to identify an inadequacy, if that is your question.
Yeah.
I think there are instances where you can identify inadequacies in the absence of regulatory requirements. However, I do think regulatory requirements are helpful for the context of a casino that is, in a position to or wanting to comply with all relevant legislation and also relevant expectations. It is, as we mentioned earlier, with the vast array of research positions and opinions, it is somewhat difficult for those of us in the industry to understand just what steps should be taken.
Can I ask you now about the change program that you've begun planning for and executing in relation to gambling-related harm minimisation? And
Yes.
first thing I wanted to ask you about is risk assessment.
Yes.
Coming back for a moment to financial crime and MLTF risk, you explained earlier that an enterprise-wide risk assessment is a fundamental component of that change program and any program,
Yes.
really, for financial crime and compliance. Is an enterprise-wide risk assessment of gambling-related harm risk a fundamental component of the responsible gaming change program?
I wouldn't say it's a fundamental requirement, but I would say it's an absolutely fantastic initiative and one that would be very helpful.
Well,
I don't believe it's a fundamental requirement because in the context of financial crime and some other areas of risk management, there are legislative expectations or legislative requirements or regulatory expectations in the context of applying enterprise-wide risk assessments or applying risk assessments to understand inherent risk. There's nothing like that exists in my experience in the responsible gaming space. However, I think it would be a very useful tool.
but absent again that regulatory or legislative overlay, it's a point that's compelling, isn't it? That in order to take...
It is. That's why I'm encouraged by the prospect of introducing one, yes.
But just to be clear, if you're going to take all reasonable steps to minimise gambling-related harm risk, you need to know what the
Yes.
risks are.
Yes, there is quite a difference in, well, obviously there's a great deal of difference in financial crime and compliance and responsible gaming in this space in that there is specific research in the context of responsible gaming that targets gaming harm and focuses on gaming harm and also on measures to address gaming harm or prevention or minimization. That is fairly unique. And so there is a basis upon which to draw conclusions on what might be appropriate for a responsible gaming program that isn't necessarily obvious in other functions. But as you said, I also think it would be it's an excellent way of approaching the identification of risk to the extent that you can sufficiently gather data and analyze that data for the purpose of the EWRA.
Has an enterprise-wide risk assessment methodology been designed for responsible gaming risks at Crown?
Not yet, but I would suggest that Dr. Blazinski has, you may be aware, has prepared a gaming risk matrix that is a helpful tool in the context of understanding what might be a component of that enterprise-wide risk assessment for responsible gaming. but it is a consideration under the Responsible Gaming Change Program.
You mentioned at paragraph 55 on page 1017, in the second sentence, when you're talking about improvements, a more robust customer risk assessment methodology. Is that the one that Professor Blazinski has prepared that you just referred to?
No, that was my idea, and it's very likely informed by some of the research that I've read. But it is my experience in financial crime around customer risk assessment models is that they can be applied in the context of other areas, and I think there is a possibility or a real prospect of building a CRA model not dissimilar to what we will apply in financial crime in the context of responsible gaming to identify customers that may be exposed to harm.
You would also be able to deploy concepts such as a channels risk assessment and a products risk assessment, couldn't you?
Absolutely, absolutely. I think customer risk assessment is sort of the initial point, but I think product risk assessment is necessary. And frankly, every new product in the context of Crown Perth is reviewed by the responsible gaming team, so as to ensure that the risks are assessed. However, I think a comprehensive approach to risk assessment in the space would be useful.
And jurisdiction risk assessment might also have some role to play here. You can see, for example, how Western Australia's regulatory overlay in relation to electronic gaming machines is different from other jurisdictions.
Yes, my understanding of the difference in Western Australia, and again, I'm not an expert, my understanding of the difference in Western Australia relates to the usage of electronic gaming machines in the absence of pokies being available in pubs and clubs. So there's a higher rate of usage and potentially a higher, thus a higher experience of harm in the context of EGMs, because that's, lower, because that is not as available as it is in other jurisdictions.
Well, it might also mean this, mightn't it, Mr. Blackburn, that where you have all of the EGM play occurring on your premises, it provides a greater opportunity to minimise the risk of harm.
I fully agree with that.
In relation to the RG Change program, Mr. Blackburn, how is harm characterised or defined?
Would you mind if I refer to the RG Change program PowerPoint?
So let me just see if I can find that document for you. Is that CRW 701-006-4437?
I think so. And bear with me, I apologize. Lots of material. It is.
It's coming up on the screen, Mr.
CRW.701.006.4437.
That's it. Put that up on the screen, please.
I'm not entirely clear that we've defined harm in the context of the program. I think we've assumed, and so we may not have defined it in this document. However, harm to me is the same definition that I provided earlier, which is relates to money and time, excessive money and excessive time, or both.
And the change program has as its objectives not only harm minimisation but also harm prevention?
Correct.
And at paragraph 71, page 1019 of your witness statement, you say that the purpose and objective of the change program waiting for it to come on. you, is to ensure Crown's RG practices and systems are consistent with best practice.
Correct.
Can I ask you a couple of questions about that? First, is Crown seeking to benchmark the change program by reference to RSG programs of other casino operators in Australia or in other jurisdictions?
Well, we certainly will be benchmarking against other operators in Australia because my understanding is we're already well advanced versus our competitors in Australia. However, overseas, I think we will do a comparative analysis as part of our RG change program. It will not be determinative, but it will inform.
Does the change program contemplate that access of the public generally to gambling services at Perth Casino may be modified or restricted in order to minimise the risk of harm or prevent harm occurring?
I apologise. Could you repeat the question?
What I'm driving at here is I want to understand
Yes.
the change program in whole or part contemplates access of the public generally to Crown's gambling services may be modified or restricted in order to minimise the risk of harm occurring.
I think that is definitely a possibility and something that would be considered under the RG change program. That's also obviously something that is, well, one of the outcomes potentially of the Victoria Royal Commission.
But does the change program currently address that point?
It does through the harm prevention and minimization actions or activities. So if I could refer you to back to the PowerPoint, we define key harm prevention and or minimization areas. That is on page CRW.701.006.4443, starting there and continuing for the next several pages. Each of these points or each of these components, these areas for prevention and minimization would consider that.
Does the change program have regard in any way to the potential impact upon Crown's revenue or profitability of certain harm minimisation strategies?
None at all.
Does it have regard in any way to whether any harm minimisation strategies might put Crown at a competitive disadvantage to other casino operators?
No, it doesn't.
Does the change program assume that the overall philosophy, approach and policy in respect of harm minimisation should be the same with respect to all Crown properties?
We haven't made that presumption. I wouldn't make that presumption based on the fact that there may be distinctions property to property. So, for example, Crown Sydney will operate a very different model than Crown Perth, which also operates in a slightly different model than Crown Melbourne.
Can I just then clarify what you say at paragraph 49, page 1016 of your witness statement? So the overall philosophy, approach and policy is the same or is not the same?
I think it will be the overall philosophy and approach and policy, frankly, will be the same for all jurisdictions, but there will be nuances in how it's delivered. So, and that nuance would allow for, say, for example, the existence of greater usage of EGMs in Perth as an example.
Well, Ms. Carl, whenever you get to a convenient time,
yes,
a convenient point rather.
Probably 2 or 3 more questions, and then you can break, Commissioner. Do you consider the fact that Crown Perth effectively has a monopoly in Western Australia with respect to the offering of casino gaming to the public as being a distinguishing feature in terms of the philosophy, approach and policy overall that should be implemented in Western Australia?
No, I don't. Gambling harm is gambling harm. It's more of a question of how you operationalize management of that harm. And I think even Professor Rockcliffe recognized that in every jurisdiction in Australia, the harm is the same. It is how you address the harm. And there may be instances of greater use of certain products, but ultimately the harm is the same. So how you apply minimization and mitigation strategies should be very, very similar.
Well, would you agree that with a monopoly situation at Crown Perth, Crown has the latitude to take a more robust approach to harm minimisation because it doesn't have to have regard to competitive disadvantage or profitability implications from its harm minimisation approach?
I'm not sure that's right, in that Crown Perth isn't only for Western Australians or Perth residents of Perth. I think the people that attend Crown Perth come from all across Australia. In fact, I think it's a bit of a tourist destination for Perth and for Western Australia. So it would seem to me that it should apply equally.
Right, we'll take a break for. We'll break till 10 minutes to 4 our time. Is that 10 minutes to 7 your time? That'll give you a time to recoup.
Fantastic. Thank you so much. I'll grab a tea.
All rise.
Please be seated. Thank you, Mr. Blackburn. Mr. Howe.
Thank you, Commissioner. Now, I want to go back to the PowerPoint presentation that you took us to before the break. Mr. Blackburn, CRW 7010064437. But just to be clear, is this intended to be, it's only in draft form and it's still being reviewed, but is
Correct.
the intention that when it's completed, it will be the presentation document to explain the change program to the CRL board?
Correct.
Now, at 4438, the uplift program objective is described there to make the responsible gaming capability world-class in the view of an independent assessor. Is the intention to have the change program reviewed by an independent assessor
That is the intention, yes.
before or after it's approved by the board?
I won't be seeking approval from the board. I'll be seeking noting from the board. So I will present the program to the board as the plan, ask them to note it, and then we will be seeking an assessment.
And who will that?
And now that assessment will very likely be conducted through, we will ask the members of the RGAP.
Will be the independent assessors.
Correct.
Now at 4440, you've got the change program design approach here, and
Yes.
numbered paragraph 1, which interestingly comes after 2,
That's why it's a draft.
identifies the review inputs,
Yes,
and that's the inputs into the uplift program. Is
correct.
that right? And do I understand that the inputs are essentially these? You've got your RG enhancements, that's one input.
That is one of the inputs. Yeah, there are multiple inputs. So
Sorry.
the Victoria,
Sorry.
no, please go.
Mr.
Yeah.
Blackburn. The RG enhancements are one set of inputs,
Yes, they are.
and then
Yes.
issues that have been identified from the Royal Commissions are another set of inputs.
Yes,
And there's a research review that has been undertaken or is being undertaken, and that's another set of inputs or another input.
correct. Correct.
Are there any others?
The recommendations associated with the Victoria Royal Commission 6th Review, the recommendations from the RGAP in their report of August 2020, and anything, of course, that arises out of the Perth Crown Royal Commission, Perth Casino Royal Commission. All of these things will continue to act as inputs into the program, and of course the Victoria. But I believe you said that Victoria report.
All right. And if you were to ultimately undertake an enterprise-wide risk assessment, there might be something coming out of that that would also potentially fit
Correct.
as an input.
Yeah, there's also a great deal of research that has been reviewed in the context of pulling this together. So there are many inputs.
Well, have you identified the bulk of them?
Sorry, yes, and I've just articulated them.
Now, at page 4444, this is the beginning of the overview of the different initiatives, and as I understand it, they follow sort of different subject matters on the succeeding pages. Here we've got
Correct.
for uncarded play. I just wanted to understand some of the terminology in this document. In the third column under category, in respect of the different initiatives, there's a category of big hitter. What does that
Yes.
mean?
Greatest impact, perceived greatest impact. So we brought together, as you'll appreciate, a number of people through workshops, in addition to getting advice from the RGAP, and the RGAP was also present, where we went through all of these various elements to determine whether or not we thought they would be, what would be most effective in harm prevention, harm minimization. And these were the items that we landed on, where we've indicated big hitter. It is indicative of something that we think would make a material difference as a group.
Material difference in terms of minimising harm.
Correct.
And the lower priority category, what does that mean?
Those are ones where we are not certain yet of the overall impact, or we regard them as being less impactful.
Now, if we go to page 4446, there's a reference to quick win. What does that mean?
Things that we think we can do relatively quickly.
And what about the...
To make a difference.
Yeah, what about the relative impact on minimising harm? How do we assess in that context?
So it would be categorized differently, but we haven't indicated there whether or not we feel it is a big hitter or a low priority, the impact, but we've identified it as a quick potential and something, frankly, many of these we'd like to do in any event. And so if there are opportunities to do things quickly, that would help people and minimize harm, then we will consider them for sure.
And small win? What does small win mean?
Small win necessarily means we aren't convinced that it will be a material change, but we think there will be incremental change.
And how does that compare to lower priority?
Lower priority would be beneath the small win. So as one that we are yet to fully assess or fully determine the impact, but we expect that the impact may not be material.
Now, at 4452, in relation to play periods.
Yes.
At the bottom there, the row dealing with research and analytics to scope play periods is described as lower priority. Why is that?
I think it's largely because in order to get to the point where research and analytics to scope play periods are effective, we need to have implemented the play periods for a period of time to actually understand their impact. So there's a collection of data required ultimately in order to determine whether or not they are effective. It's not an assessment of the effectiveness of play periods generally. It's an assessment of the effectiveness of play periods in use and in practice at Crown.
But if you were to research the general position as opposed to how it works at Crown, you could form a more confident view about whether the 12 hours is the right number. Would you agree?
I do, and I have.
So you've done research into whether...
Of course.
All right. And
of course, I think we provided you a list of the research materials that we've gone through, and many of those materials touch on play periods. There are none that are definitive in that regard, but there are several that touch on play periods.
Right. And you're satisfied on the basis of that research that the 12-hour time limit on the casino premises is appropriate?
No, and I didn't say that. I think it's more appropriate than 18 hours. You'll recall that I said, in fact, I'm open to revisiting that number as time progresses and as further research develops, and also as our data and analytics are applied in the context so that we can better understand how it's operating. Ultimately, we require the data to actually understand, as opposed to doing a desk study. The study at the casino, through observation and through analysis of the data available at the casino, will provide us with a better platform upon which to determine whether or not play periods are actually effective in minimizing harm.
But the 12 hours is not based on anything, is it? It's just your common sense reaction.
The 12 hours in its original instance was based on my common sense reaction, but I think you'll also note that the Victoria Responsible Gaming Foundation CEO indicated at the Victoria Royal Commission that he thought that was an improvement as well. So the reaction I've had to the 12 hours from experts in the field has generally been that it is a positive step for Crown in minimizing harm.
So the question is whether it's a sufficient step, Mr. Blackburn.
And as I said, we have yet to determine that.
Right. But you could do academic research that would inform that. Would you agree?
We could, so long as that academic research isn't done from the lofty heights of academia. I think the academic research would need to be informed by presence on the gaming floor and clinical experience.
Yes, but can I just be clear? Have you undertaken a review of the academic research?
We've reviewed many research articles in this regard, but as I said, and repeatedly, I have not yet come to a conclusion on whether or not it is suitable, and that will be considered as part of the Responsible Gaming Change program.
Is it a priority for you to get to the bottom of that?
It's a priority for me to get to the bottom of every element of the Responsible Gaming Change program.
Yeah, but this no more so than any other aspect of the change program.
Well, this one, I'm excited by the prospect of reviewing data from an operational perspective as it's delivered. As you know, we implemented the responsible gaming, or the play period protocol, the new play period protocol in Perth on October 4th, and we are already receiving data, but further data is required.
Now, you explain at paragraph 79 of your witness statement, page 1020, you explain that there are two documents that are in the process of being prepared that relate to the development of the change program, the two documents that you've nominated on the screen. One is an information and insights document. I can ask
Correct.
it to be opened up, CRW 70100064410. Who actually prepared this document, Mr. Blackburn?
The aggregation was conducted by Nick Emery, the Chief Marketing Officer for Crown.
The marketing officer?
Yes, it was based on the aggregation from information from a number of employees at Crown, and based on the reaction or the engagement with the RGAP, and also run through me before it was presented to the RGAP.
Is it not, though, a summary of key points from research?
Some of it is a summary of key points from research. Some of it is a summary which would have come through the GMs from responsible gaming in each of the jurisdictions, but together with the panel.
Right. Now, the blue and red comments are the comments of Professor Del Fabro and Professor Blazinski, respectively, are they?
Correct.
And is the intention that the contents of this document will be fed into the change program?
They will help inform the change program, yes.
Right. Now, in relation to play periods here on this first page, do you understand that what's being advocated by the two professors is that they are identifying a period of continuous playing on an EGM of between 3 to 5 hours as an indicator of a risk of harm that requires some response from Crown?
I do, which is why we've implemented a 3.5 hour intervention.
And if we go to page 4412 at point 9, if we go down to the bottom text under the heading Insights, first bullet point, where it says there is no adequate or realistic technology solution for in effect monitoring uncarded play.
Correct.
Is that insight being taken into account in the change program?
It is, yes.
And at the top of page 4413, is it your understanding in relation to the comments in red that Professor Baginski is identifying material limitations in the ability of staff to manually observe uncarded players for signs of risk of harm.
That is my interpretation of his response as well.
And is that insight being taken into account in the change program?
Of course.
Now, the other key document you refer to at paragraph 79 is CRW 70100644421. Now, just need this in Excel native format. These questions, please. So we just have to get the right version of this for you.
No problem.
This, you've seen this document in an Excel spreadsheet format, have you?
I have.
Yeah. And is this the most detailed and comprehensive expression of the contents of the change program in its current state?
No, this is an expression of responsible gaming controls that we have in place either now or that we are considering enhancing or developing as part of the responsible gaming change program. But this is a focus on the controls element.
So if we were to ask you, where do I go to find the current version of the change program, where do we go?
The document you were previously reviewing, which covers at a high level, all of the components that we hope to address through the change program. Now, granted, it is a draft and will be further developed.
Do you mean the insights document or the PowerPoint presentation?
The PowerPoint presentation.
But there'll have to be a proper change program document that underpins that, won't there?
Of course. Yes, not unlike what was presented to the board in the context of the financial crime change and compliance change program.
Right, but has that document not even commenced preparation?
Well, the underlying documents have commenced preparation, so we are well on the way, and we will use components of the PowerPoint presentation, which is fairly comprehensive, although albeit high level, but is fairly comprehensive on the strategies we will undertake.
Yes, no, I just have to pause, Commissioners, to see if I can find where the native format of this document is. This does not correspond. Commissioners, we might have to pause for a moment to get this document uploaded. I won't be able to ask questions on the basis of the PDF document.
I can ask a couple of questions just whilst we're waiting. Mr. Blackburn, in respect of the PowerPoint document that's been described, when was that prepared? I can't see a date on it.
It's been prepared and revised over the course of the last 3 months. The most recent iteration that you would see before you is likely early October.
Thank you for that. And is that at the moment a document that's only being used by your RG management team? Hasn't gone beyond?
It is an internal document at this stage, other than we have engaged the RGAP in respect of it, so they've seen it. But otherwise, it remains an internal document at this stage. It has been socialized with the CEO as well, with Steve McCann, but considerable further work is required before we more broadly socialize it.
And the program, the RG program that you expect to come out of that will be a joint program for both Melbourne and Perth?
All jurisdictions. So we consider responsible gaming to be a group function to ensure consistency and best practices across the organization, and also to ensure we learn from one another in each of our jurisdictions. So this will be a group program.
And how do you see that fitting with the Victorian Royal Commission's recommendations about Melbourne management reporting only to the Melbourne board?
My personal perspective on that is it's unfortunately very short-sighted in that it doesn't appreciate the impact on the sort of national presence of this organization. It concerns me that I will, well, depending on, I think Crown will take a position on it, but it concerns me as a leader in an integrity function that I will have less of an ability to acquire talent. And frankly, I'll have to, well, I'm not sure, frankly, how I'll do it from a commercial perspective, how I will develop these teams in a regional way. Because at this point in time, the expertise is shared, the learning experiences are shared, and the ability to attract top talent remains in place because we are a national organization. So I understand that the recommendation from Commissioner Finkelstein applies to specific roles in particular, and responsible gaming happily wasn't one of those roles. It was the CEO, the CFO, I believe this chief operating officer, and then there were a handful of other roles where the heads of were required to report into the jurisdiction. But my solemn hope is that that approach doesn't proliferate, in that it will be incredibly difficult for those of us on the integrity function side of the equation to effectively manage risk and effectively roll out consistent processes across jurisdictions.
Thank you. Ms. Cahill, would you like me to continue?
I've just been told, Commissioner, that it should be available to come up, but it hasn't actually hit the screen yet. So if you'd like to continue, that might be appropriate.
So I just, in respect to the Victorian Royal Commission recommendations around responsible gaming, there seem to me to be recommendations there that are not picked up in the documents, the Crown documents that I've seen so far. And so I just wanted to know what your approach to those were. For example, the mandatory pre-commitment in respect of loss and time limits.
As with that, Commissioner, with that recommendation and all of the other recommendations that came out of the Victoria Royal Commission in responsible gaming, they are being built into the program. That does not necessarily mean we will take a consistent approach depending on the outcome of the Perth Royal Commission as well. We're obviously sensitive to the results from the Perth Royal Commission, and we will adjust accordingly as that happens. However, the elements that apply to Melbourne through the Victoria Royal Commission report will be considered as part of the RG change program. Many of those elements will take time to implement. Obviously, things like uncarded play or carded play consistently across the board, identification for all customers, and predetermined limits are things that will take considerable time to implement. And I think even if I recall the Commissioner Finkelstein's comment on the your play limits, it was an instruction to the government and the regulator to institute a your play program that was mandatory. So we presumably would be responsive to that. We will respond to that as soon as the government and the regulator have proposed the terms of that mandatory your play arrangement.
Thank you, Commissioner. Now, you should have the Excel spreadsheet in front of you now, Mr. Blackburn.
Yes.
And you're familiar with that document?
I am.
Yeah, and it's got a different document identifier, which I'll read out, CRW.701.009.5656. What has been your contribution to the contents of this document?
Well, I've been engaged throughout the development of this document and the articulation of the process to actually determine impact and the consider now versus consider later components.
All right. Does it apply equally to Crown Perth and Crown Melbourne?
At this stage, it applies to Crown in all of its elements, but as it develops further, I would anticipate there will be further change, recognizing the Commissioner's comments about the recommendations coming out of the Victoria Royal Commission will invariably impact how we approach Melbourne in respect of some of these items.
I just understand how we read this spreadsheet. In the column I, categorisation, the heavy hitter is equivalent to the big hitter from the slide deck, is it?
Yes.
Has the same meaning.
Yes. Apologies. Baseball terminology.
And then the small win we can see at row 9 has the same meaning as in the slide deck.
Yes.
And lower priority.
Correct.
And then if we go to row 34, sorry, 35, quick win, it has the same meaning as it did in the slide deck.
Correct.
Now in column J, the doing it, the treatment column,
Yes.
what does doing it mean?
It means we're already undertaking efforts to implement at least a form of what the key activity is or the task.
And if we go back to row 4, and you'll see there that the doing it is as to 86%. What does that mean?
That was the response from the working group on the perception of whether or not we're actually doing the work at this point in time, and in some cases, there's a perception that it may not yet be underway. So it is a aggregate view from the working group.
And it's just derived in an impressionistic way, is it?
Correct.
As to 86%.
Yes.
And then
so impressionistic, but it's based on inputs. So each participant in the working groups was required to rate, and then those ratings were aggregated to the point where we could determine what the percentage was.
And as for the remaining 14%, that's under in this row 4 is under a consider later column.
Yes.
What does that mean?
That certain individuals in the group would have thought that it was not necessary to do now. We should be focusing on other priorities presumably within the change program. And so their advice was consider it later.
All right. Now, when the expression consider later is used, how much later are we talking about?
We haven't determined.
And so when the weightings are flipped, as in row 5 or 6 it is, do you see there where consider later is the overall treatment, there's 40% doing it, and no, it's the next row down, please. Yeah, and 57% consider later. Does that mean that less than half of it is being attended to now and the bulk is being deferred?
No, it means that in the working group, the perception was 57% of those 57% of those shared the perspective that this should be considered later as opposed to doing it now.
I see. Now, if we go to row 18, there's a consider now categorisation.
Yes.
How does one compare consider now to doing it?
Well, doing it suggests that we have already commenced the work or in the process of commencing the work. Consider now is an assessment that we potentially should consider doing this at this point as well.
Now, under columns G and H, there are scores given for impact and effort.
Yes.
Impact, I apprehend, is in relation to the impact on harm minimisation.
Correct.
How is the score derived?
Each of the members of the working group were asked to assess the impact on a 1 to 5 scale, what they felt would be the impact for harm minimization. And then that was aggregated and the average was added to the table.
And how is the effort scale or score derived?
Same process. So the members of the working group would have come from across the organization. They included people from security, from technology, from responsible gaming, of course, from compliance, from financial crime, from the gaming business, et cetera. And so each of these people would have an opinion on, first of all, impact, but also on effort.
And does effort mean physical effort?
Effort means things like technology change.
And what is the purpose of these impact and effort the effort rating?
Ultimately, to give us a sense of how difficult this would be to achieve. So that will help us plan in terms of timing.
I want to come back to this Excel spreadsheet in a moment, Mr. Blackburn, but can I just show you this document, CRW.701.006.2626. You will have seen this document before. I think it's a risk review undertaken by Cura in June of this year in relation to the risk of what's described as the irresponsible provision of gaming.
Yes.
And on the front page in the table at the bottom, if we go to the bottom of the page, it assesses various controls.
Yes.
And in the fourth row, the control of the responsible gaming Crown policy is assessed as ineffective.
Yes.
Is it an element of the change program to review and replace the responsible gaming policy?
Yes, and the codes.
Is that presently documented anywhere?
Documented in the change program, you mean?
Yes.
I'm not sure if we've documented in the change program, but it would be a component of governance. So as we go through the change program, policy is a necessary component that will require change.
Now, if we go back to this Excel spreadsheet, please, and look at the first item, which is uncarded play. Now, can I just understand what, you'll see there in the treatment categorisations, a number of doing it's and considering now, as well as some
Yes.
later. What is Crown's present intention in relation to uncarded play?
Well, Crown recognises the recommendation of the Royal Commission, Commissioner Finkelstein in Victoria, and will pursue steps towards uncarded play. As I mentioned, I think earlier, getting to a complete uncarded play environment requires considerable operational and technological change, but it is possible. It just simply will take a considerable amount of time. For example, many of the devices at Crown Melbourne and at Crown Perth are not capable of recording customer interaction. They don't have necessarily a link to a Crown Rewards card, for example. So it is considerable change is required in order to get us into a position where we can deliver on uncarded play. The overall perspective on uncarded play is that, from my perspective as the leader of financial crime and responsible gaming, is that it is helpful in the context of managing those risks and protecting the vulnerable. However, I recognize that it's a bit of a blunt instrument. I think Professor Rockloff indicated in his paper that I believe it was 0.9% of Western Australians that gamble are experiencing problem gaming. And I recognize as well that the number of Australians that are potentially at risk, even low to moderate risk, or moderate to high risk, would be less than 10% of the total. So in the introduction of uncarded play, we are taking, or there is essentially a a very sort of a refined object, but applied in a blunt manner.
So if carded play mandatory carded play is to be rolled out to Crown Melbourne, it will necessarily follow that it will be rolled out to Crown Perth?
I anticipate that is the case. However, I will respect whatever the outcomes are from the Perth Royal Commission.
And when you talk about the difficulties in timeframes, the time it will take to
Yes.
roll out a mandatory carded play system, it's also true, though, isn't it, that in relation to uncarded play, to ascertain and then roll out a system that effectively monitors uncarded players in an automated way for symptoms of risk, that's also an arduous task, because there is no current effective technology that's tried and true.
That is absolutely true. I think the impacts are slightly different, but similar in that in the context of uncarded play, building out a monitoring program that is very effective, you need to consider, of course, expenditure, but you also need to look at duration and frequency, and those elements in an uncarded environment are difficult to monitor.
Now, if we go to rows 21 to 26 of the spreadsheet, and it's looking at promotions and loyalty programs, is it correct to say here that, in summary, that essentially what's being considered is undertaking research to identify the implications in terms of risks of harm from
Yes.
promotions and loyalty programs?
Yes, and that research has begun.
And the review of those programs will only take place once that research has been analysed?
Yes, ultimately, we need to understand in the context of the loyalty program whether or not there's a causal effect. There is no research that suggests that loyalty programs have a causal effect on problem gaming. On the contrary, it appears that the research suggests that they're often associated with loyalty programs, but it's not necessarily caused by loyalty programs. So that is, in part, the angle of the research that we're trying to understand, so that it'll better inform our approach in the future.
Right. And when is the timeline for the completion, or what is the timeline for the completion of the research?
I would imagine March or April of 2022. The research is well underway. We will be distributing a survey to members of the public, people that have self-excluded in the past, amongst others, likely in late January. We're cognizant that the Christmas period is upon us, and we're eager to get robust results, and to do so, we're not sure that releasing the survey earlier will lead to that outcome.
Has a timeline been set for the completion of the research?
It was set for March. However, I think we will very likely have to push it back.
What are the additional notations in column J under Consider Now?
Sorry, the additional notations?
So it says RSCH plus RC DEP DT.
I'm sorry, I don't see that.
The cursor is...
Oh, there it is. Yes, I see it. Apologies. I don't recall.
Right. Are there any interim or precautionary steps that are being taken in relation to promotions and loyalty programs pending completion of the research?
Well, we have taken the step of ensuring that there is no marketing for those who have self-excluded at any point. That is a broader marketing initiative. But in the interim on the loyalty program, no, there are no immediate steps that we will undertake. However, we will consider if immediate steps are appropriate under the Responsible Gaming Change Program.
Now, in rows 41 to 45, there's a reference to research.
Yes.
And what you're concerned with here, the focus is Crown conducting or commissioning its own research rather than just reviewing academic literature. Is that right?
Correct.
And if we look at what is being said here in terms of column J, except for establishing the guiding principles for selection of research topics and partners, along with the process to appropriately engage with the work, between rows 41 and 45 for research, it's all in a consider later category.
Yes.
Why is that?
Simply because we have to prioritize certain items. There are many items that we are considering changing, as you will note from this document. At some point or another, we have to prioritize when to address things. And consider later would suggest that we feel the impact is not necessarily as great as the impact of some of the other priorities.
We go to paragraph rows 46 to 50. We've got the play periods there. I want to ask you about column C, where the object or the objective of the initiative is explained.
Yes.
And it's described as deliver a play periods approach that maximises customer use of risk identification in an operationally efficient way.
Yes.
Why isn't there an objective there to determine play periods that that minimise the risk of harm?
Well, as you correctly pointed out, that is the objective of the entire Responsible Gaming Change Program. It is the principal objective. All of these efforts fall into that category.
At row 47, the technology delivery, there's a reference in column F to WebEx and Splunk. Those are systems that monitor carded play periods, is that right?
That's correct.
And what is the experience to date of being able to train staff to effectively utilise that technology?
Mixed, I would say. There has been, the responsible gaming play periods have been effective in many cases, but there are circumstances where the Splunk alerts were not necessarily responded to in a timely fashion. That was raised in the Victoria Royal Commission, so you'll be aware of that. The exciting news that we have afoot is that one of the components of the Responsible Gaming Change Program that we are expediting is the introduction of new technology, which will empower not simply the RG staff, but also the gaming employees and the security staff that are present on the floor at any given time to share information, to aggregate information in respect of responsible gaming, to identify issues, and to escalate those issues to the responsible gaming team in an effective way.
We can go down to row 50, please. Cursor down. Sorry, cursor down, please. Thank you. At row 50, there's a reference to an initiative of research and analytics to scope play periods. This is to actually understand what the optimal play period ought be if it's not 12 hours.
In part, it is it's to ultimately it's what I mentioned earlier is we will be using the data collected from operationalizing the new 12-hour play period from both Crown Perth and Crown Melbourne in order to inform research, to provide that data to then inform research and analytics to then determine whether or not they are effective.
It's categorised as a heavy hitter, yet apart from doing the analytics, the extent the research is a consider later.
That is simply because we need to have the data upon which to actually conduct the research. Otherwise, it's just a desk research task.
But shouldn't it be programmed with a definite time frame within which the analytical information is to be gathered and the research completed?
Well, that is precisely what we're doing now. We're completing the data aggregation, and that is in both, Crown Melbourne, as you know, has just, as you may know, has just returned to business on a limited fashion. Crown Perth, we have the data since October 4th, but we will continue to collect data. We need a sample period that is statistically sufficient in order to make determinations based on that data.
When have you planned to complete all of the work necessary to determine an appropriate play period in Perth?
It is undetermined at this stage.
Now, if we go to rows 52 to 56, 51 to 56, there's the category of breaks in play. These are all consider later. Why is that?
Because the collective view of the working group was that the impact was not sufficiently high to prioritize over other priorities. As I mentioned, when you identify something as a consider later, that doesn't mean we won't do it. It simply means we think there are other items that can be managed, can be prioritized earlier.
At rows 84 to 89, you deal with the topic of product specification.
Yes.
And the objective here is to ensure that the RG change program addresses product specific risk. And at row 80, there's an reference, sorry, at row 86, I meant to say. In column F, identifies a key activity which is explore products that exist which assess product-related risk. And GameGuard is given as an example there. And it's rated as a lower priority to consider later with only a 1.9 score in terms of impact. Is Crown's attitude here that because the Gambling Foundation in Victoria is involved in the approval process for products, that that's a suitable proxy for determining whether or not there's any specific product risk attached to the things that are be offered? All right, so what is the rationale for the for the relatively small impact of 1.9 that's scored there?
Well, I would suggest that each individual member of the working group would have a perspective on that. But my perspective, which I'm happy to share, is that the ultimate impact of that work is better completed, that work is better completed later for greater impact.
Now, in relation to financial crime and compliance, you've set that target date for achieving financial crime risk maturity, or for the program maturity of December 2022, via an uplift program that you've developed and is to be implemented, and you're tracking progress against that program. You do not have an analogous target date or program for the implementation of the responsible gaming change program, do you?
Not yet, no, but we of course will.
When?
Once we finalize the responsible gaming change program, once we've sought notification to the board, and then going forward on that basis.
And when will those things be completed that will enable you to prepare the program? The program with the timelines.
Over the coming months.
Well, is that 1 month, 2 months, or 6 months, or 12 months?
It's over the coming months.
You can't say it might take a year to get to the point where you can develop a timetable?
No, there are elements of the program that we would be able to identify timetables much earlier, depending on the technology change, the operational change, but there are also elements that could be long dated. I think you'll notice in the financial crime and compliance change program, the target date or the aspirational date for an in aggregate advanced program has components that also don't have dates, because we need further information before we prescribe dates.
You don't have any dates though, do you, for the change program?
For the responsible gaming change program?
Yes.
We're in the process of determining those dates at this point.
Right. And when will
this is a draft, as you'll recall, this is a draft.
And when will those dates be determined by?
Some of those dates will likely be determined by December when this paper is taken to the board for notification.
And the rest?
Over time, that's how a change program works.
And can I just ask you then to clarify at 68 of your witness statement, page 1019, you were asked at question 14 about your plan to address all inadequacies or areas for improvement and how advanced the plan was, and by when and with what degree of confidence is it anticipated that your plan will have completed. You answer at 68, it's inappropriate to identify a completion date for changes, and you give an explanation as to why.
Yes.
Now, the fact that Crown's RG program will continue to evolve does not prevent you from identifying changes that are planned to be made now, does it?
No, and that's why we will be able to make certain dates available when we provide notification to the board in December.
And it's quite possible for you to also identify a target date, just as you have for the Financial Crime and Compliance program, by which time the change program will have reached a certain stage of maturity.
I don't know that yet. I will be able to better determine that when we affix dates to certain elements of the program. And also there are many elements of the program that will, as you correctly identified, require research. I can't determine external factors such as the length of time it may take to obtain research back. I can certainly hope for expected timelines, but there are external factors that come into play that need to be considered.
Well, that's true for the Financial Crime and Compliance program as well, isn't it? You're reliant on external work.
It absolutely is, which is precisely why I haven't provided dates in respect of specific actions.
Now, the change program for responsible gaming will need to proceed through the CRL Responsible Gaming Committee, will it?
It will, yes.
Will they need to approve it?
We will be seeking notification. My plan is not to seek approval, at least in the original instance.
What do you mean by that? Might there be a point at which ultimately approval is sought?
There may be for components of the responsible, as any change program for a sophisticated and complex project of this nature, you will necessarily revisit the governance structure in order to seek approval for elements of the program. There may be elements of the responsible gaming change program that change over time or that we introduce over time that I would seek board approval on.
So do I understand correctly, you would need to, you perceive the need to seek approval for an amendment to the program, but not for the program itself?
No. What I said was we will seek approval from the board where appropriate for elements of the program. That would not necessarily mean an amendment. It could mean a development of a specific item.
And will you also take the same approach with the Burswood Limited Board in respect of the program insofar as it applies to Crown Perth?
The approach I will take, as I always have, to every board is identical.
What updates have been provided to the Burswood Limited Board in respect of the IT change program to date?
None, because the Burswood Board, at its last meeting, the RG program was not developed to the point where presentation would have been meaningful.
I finally ask you about paragraph 140 of your witness statement, page 1032. You give an explanation there about providing direct briefings to Ms. Fuster prior to Burswood board meetings.
Correct.
Why do you single out Ms. Fuster in this way from other Burswood Limited board directors in terms of the direct briefing that.
Because all of the other board members are either members of senior management at Crown Perth or members of the directors of CRL.
Thank you. Nothing further.
So Ms. Fuster doesn't sit on any of these boards.
Thank you, Commissioners.
Thank you, Ms. Howe. Now, well, I think we was told we have some council in a remote location. Are there any applications from outside this room for leave to ask questions of Mr. Blackburn? I take the silence as no. So are there any applications from in the room? Mr. Darmanander.
Thank you, Commissioners. Mr. Blackburn, I know it's been days late for you. I'll try to be as brief as possible.
It's quite all right. Thank you.
Mr. Blackburn, you were asked certain questions in relation to the resources that were available with respect to the AML program and the aspirational date of 2022.
Yes.
You have some evidence about that. Can I ask you please to look at this document, CRW.701.011.1829. And this was the response prepared in relation to the views of Ms. Waldron. Are you familiar with this document, Mr. Blackburn?
I am indeed.
If we go please to paragraph 58. You see that statement there, Mr. Blackburn?
Yes. Yes.
You mentioned that certain contingencies might affect your aspirational date and some of those related to AUSTRAC. Is that to be read subject to what you say there?
It is, and it should be.
And
There are certain members of the team that would be allocated to, would have as part of their responsibility responding to the AUSTRAC investigations, but it's only a limited number of the team members.
thank you. Can I show you please also paragraph 65?
Yes.
You see that, Mr. Blackburn, and you're continuing to monitor the necessity to recruit or otherwise bring in people as required.
Absolutely. As the earlier report suggests, we are tracking that on a monthly basis, or even more frequently, frankly, on a fortnightly basis, to understand potential impacts and to address those impacts as they arise. That's the effectiveness of the reporting process.
Thank you. You were asked certain questions this afternoon in relation to the adoption of particular measures in relation to responsible gaming, including going cashless. Can I direct your
Yes.
attention, please, to a letter written by Allens to the solicitors assisting the Commission, which is PCRC.0004.001.001. See that letter, which is dated 26 May 2021, which is after your arrival at Crown?
I do.
And if we go, please, to the third page of that document, and blow up the box cashless. So this letter represented the measures that Crown was to adopt across all its casinos. This is no.
Correct.
Thank you. You can remove that document. You were taken this afternoon to an RG risk register, CRW.701.006.2626.
Yes.
Are you aware of who prepared this document?
I believe it was prepared by internal audit, but I'm not convinced of that.
Do are you aware whether, if you look at the risk owner identified, it's noted as Melanie Strelaine Folks? Do you see that in the top
Yes.
of the page?
Correct.
Were you involved?
Melanie is the. Yeah.
You could go ahead.
Sorry.
You,
No. All good. All good. I think they know who Melanie is.
Yes. Were you involved at all in the preparation of this document?
I was not. No.
Are you familiar with how these type of risk registers generally work?
I am.
If you go to the first page, the first identified risk is the irresponsible provision of gaming. Do you see that?
Yes, I do.
And if we go to the previous page, so the risk is identified as the irresponsible provision of gaming, and the controls in place for that risk are then set out at a table at the bottom of the page. Do you see that table?
I do.
And the author has given a rating as to how effective that control is in managing the relevant risk. So,
Yes.
taking the table, if you see that the workplace restrictions are rated as effective at managing the risk,
Yes.
and the RG Crown policy is rated as ineffective at managing the risk,
Yes.
is that, recognizing your awareness of how these documents operate, is that a reflection of the circumstance that the RG Crown policy is a high-level document, unlike
Yes.
workplace instruction, and so does not provide the detailed instruction to employees on its own?
Well, of course, I'm not the author of this document, but if I were the independent auditor or the person that prepared the document, I would say that the RG Crown policy is not actually a control.
Thank you. You were also asked certain questions about the research that's to be undertaken concerning the loyalty program, the Crown Rewards program. Can I have on private screens, please, CRW.700.104.2200. Is this the Crown Rewards program responsible gaming study that you have commissioned?
Correct.
Thank you, Commissioners. We'll attend to the tender of some of those documents in due course.
You,
While I'm standing up, Commissioners, I can inform you that Crown has no objection to the publication of Dr. Philander's report, a matter that you raised with me yesterday.
thank you. But the reports will go together.
Yes.
Yes, thank you. Thank you. Mr. Evans?
If I could for one moment, thank you, Commissioners. Mr. Blackburn, my name is Evans. I appear for the Gaming and Wagering Commission.
Pleased to meet you.
Could I just invite you to look at paragraph 137B of your witness statement, which is CRW 998-002-1. So 137B, roll up to page 24. Thank you. Now, a number of present and former officers of Crown in the course of this Royal Commission have accepted that it is incumbent upon Crown Perth as a regulated entity to display absolute candour towards its regulator. Is that a position which you share?
Yes, it is, absolutely.
You are aware of the history of engagement, or some aspects of the history of engagement between Crown Perth and its regulator in the past, and the way in which Crown Perth operated with its regulator?
I have no direct insight, but I am aware of it, generally through media and word of mouth.
So you're aware that there was, for example, what I call colloquially an operating committee which met periodically between Crown and its regulator to discuss regulatory issues?
I understand that to be the case.
And it again, to use the colloquialism, it road tested regulatory initiatives before they were put before the Gaming and Wagering Commission?
I'm afraid I don't have that much insight.
I was just wondering if in the light of the history, and you may not have adequate knowledge of the history to be able to do so, but you could actually put some content into what, with respect, appears to be rather a motherhood statement, that is that you would seek to build an informative and responsive relationship with the Gaming and Wagering Commission as a non-financial crime regulator.
Yes.
Can you put some...
Absolutely. So my approach to regulatory engagement has been consistent over the many years that I've been involved in financial crime. And happily, I've had the opportunity to deal with regulators and engage with regulators globally. And that has not changed since I came to Australia. My approach with respect to AUSTRAC has been to be open, frank, and forthright and candid, and also to engage AUSTRAC in the financial crime context in the overall regime to manage financial crime as a state, as a country. And that has come through in the context of Fintel Alliance and other engagements with AUSTRAC, joint opportunities. I apply the same perspective on the state gaming regulators. I believe that the state gaming regulators are a critical part of the regime to manage and mitigate financial crime. And so my perspective is that I will work incredibly closely with them to the extent they want to work closely with me, which has been the case, at least in New South Wales and to some extent in Victoria. But I am keen to work very closely with the regulators to ensure that we are managing this risk in a sort of collective fashion.
Just to understand, you put that almost entirely in the context of financial crime risk. Obviously, the regulatory focus is far wider than financial crime risk in relation to gaming and wagering regulation. Indeed, many of the questions which Ms. Cahill has put to you earlier relates to non-financial crime risks.
Absolutely. I would take the same approach, though, as you know, I'm new to the responsible gaming space, though I have been involved in this for the last 9 months, and I've made efforts in every instance where I've made a material change in the responsible gaming context to inform the GWC and also to offer opportunities for the GWC to engage with me, to ask me about the change, including the RG enhancements. I shared those with Duncan Ord before he left the organization, and I've shared subsequently with Nicola Perry and Lainey Chopping a number of updates in respect of all elements, financial crime, responsible gaming as well.
Thank you, Mr. Blackburn.
Of course.
Any other applications?
I just got one question I didn't manage to ask you previously, Mr. Blackburn, and that was in respect, I think they're probably the spunk alerts that you referred to with Ms. Cahill. And
yes.
Are they the alerts that go to RSG when a patron has been on an EGM on carded play for greater than 3 hours?
3.5, yes.
3.5. And yes. I wanted to know whether you had any knowledge as to whether there was an issue currently at the Perth casino with those alerts being responded to in a timely fashion.
The initial alert, no. Happily, so operationalizing this has introduced lots of opportunities and also challenges, in that it is a new process. As every new process, we encounter opportunities and challenges. I would say in this context, the challenge has been typically at the later interaction stages, not based on responsiveness, because we've tasked a team of 20 members from the gaming business, together with the RGAs and the responsible gaming team, to conduct those interactions. Where we've encountered operational challenges is instances where customers may have been on site for extended periods of time, but not on games, so not on machines for extended periods of time. So they were frankly surprised by the tap on the shoulder in some cases. In many cases, that was received very well by our customers, but in certain cases, our customers found it a bit of an invasion of their privacy. And so we had to explain the purpose of the interaction. But that is manageable through operationalizing, through better scripting, better engagement models. But that has largely been the issue with operationalizing, as opposed to responsiveness to Splunk alerts.
So you don't know of any issue in respect of responsiveness or lack of responsiveness to Splunk alerts at the Perth casino?
My understanding is that the responsiveness is working effectively. I think there may be individual instances where something may have happened, but not in any way material.
All right, thank you, Mr. Blackburn.
Of course.
Mr. Blackburn, I've got a few questions for you. The first one, I want to, it's about the phrase criminal infiltration.
Yes.
Now, early in your exchanges with Ms. Cale, you said that the financial crime focus was primarily, not entirely, but primarily on money laundering and terrorism financing.
Correct. Correct.
We speak broadly, and our terms of reference talk about criminal infiltration in the casino industry.
Yes.
And and I suppose it's relatively easy to understand the term criminal infiltration if you're going to apply it to money laundering.
Yes.
It's also relatively easy if you're going to apply it to criminal activity such as drug dealing within the confines.
Yes.
Leaving those sorts of things to one side, what do you see in a practical sense as the meaning and import of criminal infiltration in the casino industry?
So my perspective is that there are components of criminal infiltration that are covered by AML-CTF and by our management and mitigation of those risks, in that we are identifying, detecting, deterring, and disrupting crime and financial crime through our reporting mechanisms. However, to your point, and I fully agree with it, it extends beyond AML and CTF. It extends to activity that is actually occurring on the Crown properties, wherever that may reside, and activity that would typically be the subject of scrutiny and surveillance through our security and surveillance teams. Those are operational teams that exist in Crown Perth that are run by Brian Lee, an individual, a GM for security and surveillance that reports to Lonnie Bossy. But when I consider criminal infiltration, I consider it collectively. I consider it in the context of AML-CTF and on-site predicate offense activity. Now, recognizing much of the activity that would have been, that could be present through infiltration is the type of activity that actually leads to money laundering, because it is the predicate offense for money laundering. But I recognize that at the predicate offense stage, it is a different application.
Right, thank you. I want to turn now to the concept of risk. Now, if we look at risk within the vernacular, like exposure to danger or the potential for harm, that's a common understanding of risk. But when we come to apply it in the casino context, and we've got some fundamental components, which I think in terms of risk assessment, channel risks, jurisdictional risks,
Yes.
Product risks, and customer risks. They seem to be
Yes.
the main ones, I think, aren't they? The main fundamental components of risk?
Yes, I think so risk, of course, is broader than that. And whilst I'm a risk professional, I apply risk in the context of financial crime in my operations, and also in the context of compliance, and arguably in the context of RG, but responsible gaming, but less so. It's very clear in the context of financial crime. There is a broader risk function at Crown that is run by an individual named Ann Seegers, who is the Chief Risk Officer. She would have oversight of other risk categories that would go beyond what we just talked about. So they would include things like operational risk, technology risk, technology interruption risk, business continuity risk, things of that nature. So it is broader, but for the purpose of fin crime and frankly for the purpose of responsible gaming, it is precisely what you said. It goes down to the core elements of customer risk, product risk, channel risk, and in some cases, jurisdiction risk.
All right. Well, now let's just follow that through, that because this is where my thinking is far from complete. Where do the typologies fit into this? And let me just tell you why I'm asking this question. We've heard evidence that in a general sense of organised crime, the organised crime and money lending, organised crime is generally one step ahead of the game, and the typologies are changing. The way they use entities and various industries changes from time to time. So, and what you said in in the exchange was that the typologies are an inherent risk, but where do they actually fit? Are they simply indicia of the fundamental components, or are they what you are actually looking at in a risk assessment in terms of financial crime?
Commissioner, it's both. It's both points that you spoke of. It starts as indicia. So, for example, in the Deloitte review, forensic review of our patron accounts, they identified 10 criminal typologies. Those criminal typologies were assessed against our account activity and also against our controls. Those criminal typologies represent potential, not certain, but potential indication of money laundering or terrorist financing. And so that is the fundamental basis upon which we start our assessment of the activity. In any of those instances, you would take the typology, you would apply it to the behavior associated with that customer, the KYC associated with that customer, to determine whether or not, in fact, that risk is manifest. So it starts as an indicator, but then it becomes part of the risk assessment process so that you can determine whether or not you actually have a suspicious matter that requires reporting.
All right, thank you. Now, my last question is still on risk, but I'm now transferring attention to the role of the board. And this is going to be a fairly long lead in to the end question, and I'm not going to ask you for a legal interpretation of the AML legislation, but in an exchange with Ms. Carl about the identification of risk, you drew a distinction between with the role of the board between identifying the risk and oversight of the AML program. And you said that the role of the board is oversight, not identifying the risks. Right? Now, then the focus turned to the financial crime operating committee. Is that what it's called? The one
oversight committee. Yes, the financial crime oversight committee. Yes.
And you said it would report to the board of Crown Resorts Limited, probably through that board's risk committee.
Correct.
And additionally, that it would not report to but present to the board of Burswood Limited, probably through the CEO of Crown Perth. Right? Is that
correct?
Okay. Now
that's correct. Yes.
Under the November 2020 joint AML program, it's the board of Crown Resorts Limited that's got the oversight function. That's the only.
That's correct.
That's the only board that's mentioned in the joint program. And then we've got this concept of a designated business group.
Yes.
And as I understand it from the November 2021 draft money laundering enterprise-wide risk assessment, the designated business group for Crown are the three licensees or potential licensee in the Sydney case, which is Crown Melbourne Limited, Burswood Nominees Limited, and Crown Sydney Gaming. Proprietary Limited. Now,
Correct. They are the reporting entities. Yes.
so here we come now to what I'm actually asking. Burswood Limited is neither a member of the designated business group, nor is it mentioned in the program, in the joint AML program. So if there's an oversight function that arises directly from the legislation and preserved as such, even though there's the oversight function mentioned in the joint program as residing in Crown Resorts Limited, if there is a residual oversight function, it would, at Perth level, it would reside with the board of Burswood Nominees Limited.
Yes.
I've just asked you to accept that for the moment. So now, go on.
Perhaps let me clarify. The designated business group has Crown Resorts Limited as the delegated authority to apply oversight. So the boards of Burswood Nominees, the board of Sydney Proprietary Gaming, and the board of Crown Melbourne have delegated their authority to apply oversight to the program to the designated business group owner, which is Crown Resorts Limited. With that being said, and as I mentioned earlier, I take the approach of ensuring that every board, regardless of whether or not it's delegated its authority, is informed and aware of the risks associated, and not just the risks, but also the progress on financial crime change and responsible gaming as well, and that includes Burswood.
And so here is the question: that if all of that is correct, then the entitlement, to use a phrase, the entitlement of Burswood Limited to receive information about money laundering matters can't be found in the legislation, nor can it be found in the joint program. So looked at from the point of view of a director of Burswood Limited, where would that director look to find some document or some other form of authority for the board of Burswood Limited to insist that it be involved in this process?
Yes. So, if I may, so the part A of the program. Can I give you the CRW number, Commissioner? Shall I give you, or shall I just describe what I see?
I think we know which one we're talking about. So,
okay, that's part of the A of the program. The last four digits are 0110. Of course, introduces the concept of the business of the designated business group, and that's at section 2.3, and it identifies the Crown entities that join that business group. And that can change over time, obviously, as we create new entities. But I think you will find that by virtue of being identified as a Crown entity, Crown Perth, through Burswood, is introduced as a member of the designated business group. Now, you're correct that there is no articulation of entitlement to review. That is typically how it works for reporting entities that form a component of the designated business group. However, as I said, that's not my approach to sharing information.
You mentioned Crown Perth there. Are you saying that we should read Part A as meaning that Burswood Limited is, as a Crown entity, is part of the designated business group?
Yes, the definition in Part A for Crown entity means the casino reporting entities. So, and it means therefore Crown Melbourne, Crown Perth, and Crown Sydney. And I want to now identify Crown Perth is then defined as Burswood Nominees Limited as trustee for Burswood Property Trust. So it is by referencing incorporated.
Burswood Nominees, though, not Burswood Limited.
Correct. Apologies. Yes, Burswood Nominees.
And the reason I ask is that this has been a live issue in the in the
Yes.
in the commission as to where the companies fit together and how they operate.
Yes.
All right, thank you. That's sufficient for my purposes. Anything else, Mr. Shaw?
I don't wish to re-examine, Commissioner.
All right, thank you. Mr. Blackburn, I know it's very late where you are. Thank you so much for your time. I know you're very busy, and that our gratitude to you is increased by that. We have been assisted by your evidence. Thank you very much. You're now free to go. We've got some housekeeping to attend to, but we can.
If I may, Commissioner, I very, very much appreciate the opportunity to present and to provide evidence. I think this is an extraordinary opportunity to help progress Crown Perth and all of the Crown entities. So thank you for the opportunity. Much appreciated.
Thank you, Mr. Blackburn.
And congratulations on completing this phase of the inquiry.
We can release Mr. Blackburn. Just a couple of matters. We've dealt with the reports. I'd just like to finish by saying that so far as we are presently advised, and I say this with absolute and complete resolve, this is the last of the sessions for the gathering of evidence. I would like to just acknowledge the assistance that we've received from our technology and transcript contractors, and particularly Mr. Jack DeWeg, who's in the room, who has very kindly delayed going on to a much more pleasurable existence and life to see us out. Thank you very much. I'd also like to acknowledge the immense amount of work that's been put in by the lawyers and administrative staff of the Commission to get us to this stage, and also to say that the Commissioners are recognise the good level of cooperation from the parties, which has assisted. We are now on a extremely tight time frame, and there will be very little room for slippage, and so we proceed in the full confidence that that level of cooperation will continue. And I'm sure that no one will hold the Commissioners responsible for the development of either the Julian or the Gregorian calendar, or the designation of festivals within those calendars, which does impact on our timetable. But thank you very much. We will now adjourn to a date and time to be fixed.
All rise.